Hello and welcome to another Steps of Sussex live channel episode. Today is the 11th of February 2021. Yes, I have gotten used to saying 2021 finally. For ages I was still saying 2020. And anyway, today's video is going to be about the court case that has been ongoing, and of course we knew that Meghan had applied or put in for a summary judgment to be made, and Justice Warby has basically summarised and actually granted that summary judgment today. So we're going to be talking about that. So I'm trying to think the best place to start to kind of tackle all of this. This literally happened about an hour ago. We got all the information through. I'm going to put a link into the main chat room, and also for people watching after this has finished being live on catch up, I'm going to pop the link into the description box as well. So I actually have the documents for the press summary and the entire 53-page summary judgment that Judge Warby wrote. Now, I've just spent the past half an hour going through 53 pages of basic, legal jargon and all the rest of it. I had to skim read some parts of it because it was quite hard going, I'm not going to lie. But here is the link to kind of both parts. So right now I am going to read and go through, I think, the press summary, which hopefully it's only 3 pages long as opposed to 53, which obviously will help us understand a little bit more. But basically, in a nutshell, I'm going to try and break it down as much as I possibly can. Meghan has, in the summary judgment, won the privacy part. Don't forget, this case was split into two sections, if you like, 2 parts. There was the privacy and there was the copyright. So Meghan has won on a summary judgment the privacy part of it. In other words, the Mail on Sunday, the Mail Online, the Mail Associated Newspaper Group should not have published as much of that letter as they did. The judge has said that there was no public need for that to be published. However, they could have published like a tiny fraction of it to basically what they're trying to say is Thomas Markle has a right to put his case that the People magazine article was in part false against him. So he has a right to come back. So they could have published a tiny part of it just to justify that the People magazine article was inaccurate. So they're saying that he could have done that, but the judge is saying that the Mail went too far and obviously published too much of the letter, which then broke the privacy. I think I'm getting that right. I think from amongst those 53 pages, I think that's what I got from it. But like I said, they broke the privacy in large. So basically the judge threw out most of the Associated Newspapers' justifications for doing that. However, he couldn't come to a summary judgment on the privacy part, on the copyright part of it, because there is some disagreement, confusion going on as to whether Crown copyright comes into it, because was Meghan the sole author, the original author, the only copyright holder of the letter? Meghan is saying that she has an electronic draft on her phone that proves that she is the sole author. But the Associated Newspapers are saying that perhaps Jason Naff had some involvement with the letter writing or construction. If it is that that's the case, obviously a full trial is needed to find that out. So that is why the copyright part is going to full trial. If it does find that Jason Naff did have some involvement in it, then that creates a separate copyright. So Meghan has a copyright, Jason Naff would have a copyright. In his position as working for the royal family, that then makes that copyright Crown copyright, not an individual copyright for Jason Naff. Now, of course, the Crown, the royal family, have not put in a complaint against copyright. It is just Meghan that has done that off her own back. So if it did get to the point where if it did get to the point where Crown copyright was brought in, I imagine the royal family, or at least people representing them, would have to make a decision as to whether or not they wanted to object to that copyright being put out there as well. So we'd have to kind of get to that point as and when it actually gets to trial. So let's just read the Judiciary of England and Wales press summary, published the 11th of February 2021. Interestingly enough, in the legal documents, Meghan is referred to as HRH. So in legal documents, it seems like the HRH is still officially being used, but obviously not for private work matters. So HRH, the Duchess of Sussex versus Associated Newspapers Limited, Mr. Justice Warby. So point 1, following a hearing on the 19th of the 19th of 2020, legal jargon. That's just the date. January 2021, the court gives judgment on the claimant's application for orders striking out part of the defence and entering summary judgment in her favour on her claims for misuse of private information and copyright infringement. The action and the application. The claimant is the actor Meghan Markle, also known as the Duchess of Sussex and wife of His Royal Highness Prince Henry of Wales, the Duke of Sussex, whom she married on the 19th of May 2018. The relationship between the claimant and her father, Thomas Markle, was difficult at the time. On the 27th of August 2018, she sent him a 5-page letter, otherwise known as the letter. This action arises from the later reproduction of large parts of the letter in articles published by the defendant in the Mail on Sunday and Mail Online. The existence of the letter first became public on the 6th of February 2019 when it was mentioned in an article in the US magazine People. Mr. Markle then provided the defendant with the letter. On the 9th of February 2019, the defendant published the Mail articles under headlines, the gist of which is conveyed by 1, revealed the letter showing true tragedy of Meghan's rift with a father she says has broken her heart into a million pieces. And 2, the Mail articles drew extensively on the words and information in the letter. In this action, the claimant alleges that this involved misuse of her private information, breach of her data protection rights, and infringement of her copyright in the letter and of a draft letter of the letter she created on her phone, otherwise referred to as the electronic draft. The defendant denies that the claimant had any reasonable expectation of privacy in the contents of the letter. Alternatively, it says any such expectation is outweighed by the need to protect the rights of her father and the public at large. The defendant denies that the letter is an original literacy work in which the claimant owns the copyright. Alternatively, it relies on defences of fair dealing, public interest, and freedom of expression. Its case includes reliance on allegations that the claimant discloses information about the letter to the authors of a biography of the Duke and Duchess of Sussex published in mid-2020 called Finding Freedom. And of course, Omid was brought into this whole debate. So by not going to court on the privacy issue, Omid is obviously not brought into a full trial situation. The claimant now applies for summary judgment on the privacy and copyright claims. Her case is that the defence discloses no reasonable grounds for defending the privacy claim, and the defendant has no realistic prospect of successfully defending either claim at a trial. The hearing is not concurred with the data protection claim. The court identifies the principles that govern striking out and summary judgment, the timing of the application and the evidence relied on by each side. The judgment then addresses the privacy and copyright claims in turn. Misuse of private information. The judgment identifies the essential legal principles and the issues for decision. The essential facts are then set out, including the father-daughter relationships at the relevant times. Also, Mr. Markle's reply, the People article, dealings between Mr. Markle and the defendant's editorial process, the fact that the defendant made no contact with the claimant, and the contents of the Mail articles, which are set out or described in some detail. Some details of the legal proceedings are mentioned. The defendant's case on the book is summarised, and key passages are set out. Like I say, you can read the full 53 pages if you want to. The merits of the case are then considered in detail, applying the two-stage test required by the law of the court. And it concludes that the claimant had a reasonable expectation that the contents of the letter would remain private. In other words, Meghan wins. The Mail article interfered with that reasonable expectation. The only tenable justification for any such interference was to correct some inaccuracies about the letter, which is what I said, that Thomas did have kind of some rights to be able to put the People article straight, contained in the People article. On an objective review of the articles, in the light of the surrounding circumstances, the inescapable conclusion is that, save to a very limited extent, the disclosures made were not a necessary or proportionate means of serving that process. In other words, the Mail published too much of the letter. For the most part, they did not serve that purpose at all. Taken as a whole, the disclosures were manifestly excessive and hence unlawful. There is no prospect that a different judgment would be reached after trial. So he's saying, even if it went to trial, it's almost impossible that another decision could have been made, basically. The interference with freedom of expression, which those conclusions represent, is a necessary and proportionate means of pursuing the legitimate aim of protecting the claimant's privacy. So in other words, freedom of expression doesn't trump the claimant's privacy, so Meghan's privacy. The limited exception referred to is that it was legitimate for Mr. Markle and the defendant to use part of the letter to rebut false suggestion in the People article that the letter represented some form of olive branch from the claimant to Mr. Markle, but it was neither necessary nor proportionate for the Mail articles to disclose any of the rest of the information in the letter. So it is what it says. The court sees no useful purpose in striking out any of the defence. Parts of it might be relevant to damages, and the work involved in filtering would be disproportionate to the gains. But there is no good reason not to enter summary judgment on liability. There are compelling reasons not to allow this aspect of the case to go to trial. Bear with me, we have one more page to get through. The claimant limits her case to the electronic draft. The judgment summarises the essential legal principles. It identifies the issues which are then addressed. The law on originality is set out. The defendant's case on the issue is summarised. The court concludes there is no basis in law or fact for that case. It is satisfied that the electronic draft is and would inevitably be held to the product of intellectual creativity sufficient to render it original in the relevant sense and to confer copyright on its author or authors. The court finds for the claimant on infringement. Quantitatively, the Mail articles copied a substantial part of the work, some 585 words of the total 1,250. It is undeniable that they reproduced a substantial part in qualitative terms, and, in the sense, they are reproduced a substantial part of that which is the author's own intellectual creation. The court analysis for the purposes of stage 2 of the privacy claim leads to the conclusion that the defence of fair dealing for reporting current events could not succeed. This is not one of those rare cases where freedom of expression trumps copyright. There is no basis on which the court could conclude that, although the copying was not fair dealing, the public interest required the copyright to be overridden. The court is persuaded, however, that there should be a trial limited to issues relating to the ownership of copyright. This is what I was saying about the Crown copyright and Jason Naff's potential involvement. The defence argues that a trial might show that the works are works of joint authorship, or that there are several copyrights with different ownership. It relies on admissions by the claimant, hearsay evidence, and a solicitor's letter to suggest that the involvement of staff on the Kensington Palace communications team, the Palace 4, may have generated a copyright that does not belong exclusively to the claimant and may be classed as Crown copyright. The court regards the defendant's factual and legal case as occupying the shadowland between improbability and unreality. It is not easy to identify a useful litigious purpose. In a trial, the substantive effect of which would be, at best, to whittle down the remedies, but proportionality is not the criterion. The case cannot be described as fanciful, and these issues must go forward to a trial. There will be summary judgment for the claimant on the claim for misuse of private information and on the other issues in the copyright claim. A hearing to decide matters consequential on this judgment and directions for the next steps is fixed for the 2nd of March 2021. So there we have it. The reason why I read through those 3 pages of kind of legal words and jargon was basically so that no misinformation can be put out there. When you watch this channel, you are getting basically the facts. So that is exactly what's been said. Those are the exact words from the document. As I said, I have copy and pasted that for you. I will copy and paste again into the description if you are watching on catch up. I haven't twisted anything. I haven't manipulated anything. That is the facts as they are. Right, I'm also going to read now Meghan's response to that. So, a statement has been put out on behalf of the Duchess of Sussex. So Meghan's response reads, "After 2 long years of pursuing litigation, I am grateful to the courts for holding associated newspapers and the Mail on Sunday to account for their illegal and dehumanising practices. These tactics and those of their sister publications, the Mail Online and the Daily Mail, are not new. In fact, they've been going on for far too long without consequence. For these outlets, it's a game. For me and so many others, it's real life, real relationships, and very real sadness. The damage they have done and continue to do runs deep. The world needs reliable, fact-checked, high-quality news. What the Mail on Sunday and its partner publications do is the opposite. We all lose when misinformation sells more than truth, when moral exploitation sells more than decency, and when companies create their business models to profit from people's pain. But for today, with this comprehensive win on both privacy and copyright, we have all won. We now know and hope it creates legal precedent that you cannot take somebody's privacy and exploit it in a privacy case. And the defendant has blatantly done, over the past 2 years. I share this victory with each of you because we all deserve justice and truth, and we all deserve better. I particularly want to thank my husband, mom, and legal team, and especially Jenny Afia, for her unrelenting support throughout this process." So that was Meghan's response. The only bit I'm a little bit kind of unsure about was when she said about the comprehensive win on both privacy and copyright, because the copyright part of it is still going to trial. So I think what she means is Judge Walby recognised that she does have copyright, but that obviously she may not have complete and total copyright, because there may be additional copyrights that may come under Crown copyright. I think that's basically the gist of the whole thing. So that was Meghan's response. And I also have the response from the Daily Mail. Now, I wondered how the Daily Mail was going to report their own loss, basically. So I went to the Daily Mail online to see, first of all, even if they had reported on it, because I was half expecting them not to even report on it at all. And if they did, what kind of spin they were going to put on it. So they responded with, "Meghan Markle wins privacy case against the Mail on Sunday and Mail Online over letter to father," and without is in capital letters, "without a trial. Publisher considers appeal." So it looks like they are going to consider an appeal. Let me read what it says. So a spokesman for the Mail Online said, "We are very surprised by today's summary judgment and disappointed at being denied the chance to have all the evidence heard and tested in open court at full trial. We are carefully considering the judgment's contents and will decide in due course whether to lodge an appeal. So there we go. And I don't think they've added anything else to the article. They've obviously gone through in their own way what happened. So yeah, basically that was their response to it. So I'm going to go now. I realise I haven't read any comments. We have 146 people watching, so hello to all of you. I'm going to start at the bottom, I think, and kind of read up a little bit. Oh, by the way, there is obviously going to be so many royal correspondents and royal reporters, people in the media talking about this judgment. I imagine there will be a Piers Morgan article written on it. There will be probably all these different people coming out. But the one thing that I wanted to do was just put out the facts in this video. I read the 3-page press summary. Facts. That is exactly what happened. I read Meghan's response. Fact. That is exactly what Meghan said. And I've read the Daily Mail or the Associated Newspapers' reaction to that, their statement. That is a fact. That is what they have said. So I'm hoping that in this video we have all the facts in one place. There's been no spin put on it. I haven't come at this from any angle of bias or anything of that nature. I'm hoping no one is going to be thinking that. I've literally just come and said exactly what has happened in this case. So I'm hoping people are going to feel the benefit of that at least. Right, let's go up a little bit. Let's have a look. Ashley, I'm going to just pick a comment. Ashley says, Meghan was allegedly calling the paps on herself as well, like a lot of celebrities do. I don't buy into the media promoting broken relationships between black children and dads. Well, I mean, going back to the start of all of this, when Thomas Markle was basically trying to, sell himself for paparazzi staged photographs. That's kind of what started all of this. And yes, a lot of celebrities do set up photo opportunities. Diana herself, Princess Diana, back in the day, did used to tip off the press as to where she would be to see if they could get a photograph. So yes, it does indeed go on. Maddie says the Associated Press and their subsidiaries tried to make the case in circus and make money off of it. I'm happy about the outcome. Yeah, it was a weird one because obviously this case was going ahead, and obviously even now they are having to write, well, they haven't got to, they are choosing to write articles about a court case which they are part of, which obviously could be classed as being unethical in itself to do that. Nellie says, how a parent can sell out their own child is beyond me. Thank goodness Meghan has her mother. H. London says, I am thrilled for Meghan. Her father really let her down in so many ways. I hope he keeps silent here forward. Miss Dynamite says, wow, great news. Congratulations, Duchess Meghan. MSNB says, it was an invasion of Meghan's privacy. Lauren says, sadly, I think family relationships can be difficult at the best of times, never mind when they're in the public eye. That is most definitely true. Claudia says, what? Duchess Meghan won that case. I am so happy. What is the main case? Hooray. Claire says, great news. They must keep suing the disgusting rag. And I'm just picking random comments, literally. I'm going to go down to the bottom again. Cerezel 22 says, why the royal family need to say something if they are not involved in it? That they haven't said anything on this court case. So if you're saying, why have they haven't said anything on it. What I think they may have to do, if obviously when this goes to trial, if it is that Crown copyright comes into it, then they may have to say something then as to if they want to uphold that Crown copyright. Or it might just be a look at, well, Meghan doesn't have complete copyright of it, therefore she can't win on sole copyright grounds. It could either go one of those ways. I don't know. I'm not a lawyer. I'm not a solicitor. I'm probably in the dark as much as you are on all of these kind of legal matters. But I'm imagining it would be one or the other of that. Betsy O'Farrell says, thank you for the clarification on this case. Hi, Betsy. I just wanted to kind of just say exactly what the facts were. Nelly says, if you think the tabloids are ever going to leave Meghan alone, think again. Every time they write about her, they make money. And Darlene says, no, please, no appeal, just end it. I think a lot of people, well, I don't know, people might have different opinions on it. Some people might want it ended. Some people might want it to go to full trial so that, you know, everything is looked at, that, you know, every aspect is scrutinised so that the truth, the full truth kind of comes out, I guess. So I suppose it depends on which side of the coin you look at it from, I guess. Has Thomas spoken out? Not that I'm aware of at the moment. So I am going to leave this video here because I wanted it to be quite concise, to the point. I think I've done that in this video. Like I said, I've looked at what the press summary is. As I said, I'm going to put the links in the description box for you to go and read the 53 pages if you so want to. It's a bit of a slog, but, you know, I pretty much got through all of it. I've said what Meghan's response is, and I've said what the Associated Newspapers response is as well. So if you found this video useful, please give it a big old thumbs up. Feel free to leave a comment. I know everyone's going to have different views, but please try and be respectful to each other and also yourself as well. And obviously make sure you subscribe to the channel for any future updates. So from me in Shropshire, mwah to you all, and goodbye.